Stable.
Good. Live
Okay,
on
we
YouTube.
started streaming live.
Yeah.
It's being set up and it's going to go live. So I'm
Good.
going to introduce. Hi, everybody. Welcome to this session on post-lockdown and during lockdown implications for employees and workforce and organizations. So this is an employment law related focused session. And we have with us Ashok Naik, sir. He has more than 40 years of experience uh, as an employment lawyer, and he has donned this hat in many capacities. He's worked with private banks, he's worked with public sector banks, and he has independently been a labor laws practitioner as well. Okay, and so we are extremely excited to have you with us in this session. I'm going to invite the participants to keep messaging me and share your current background. Are you working in a company? Are you currently practicing law? Where what do you currently do? You can please keep sharing on chat so that sir also has an idea of the participants here. So, and I'm going to start the conversation with sir. Sir, thank you for being with us.
Yeah.
And I'm going to start out with this, sir, that, suddenly when on March 22nd, I think that was the date when the first lockdown was started. And people went in a big tizzy and they were struggling to move to a remote workforce environment. And from 3rd May onwards, now what happened was that the country was divided into zones and people struggled with a lot when it comes to paying salaries because there are sectors which are hit. And I'm going to obviously invite you, sir, to share from your inputs about what's happening in different sectors. But essentially, maybe you can help us with by sharing an introduction of how which sectors are hardest hit and how organizations in private and public sector are dealing with the situation. That is how, so you can say, and you could share a little about your practice at the tribunals, labor courts, and in the past, sir. So you got muted somehow. I've just unmuted you. No, it's not happened. You got muted, sir. 1 minute. Yeah, now you're unmuted. Yeah. Please, sir. No, I can't hear you. Your volume is low. Can you increase the volume of the mic? Hello? You got muted. It's getting muted from your end.
Myself.
Now it's fine, sir. You can continue.
Okay. In between, there's some call coming. So.
Okay.
Yeah.
You got muted again. 1 minute. So I'm unmuting you. Why is it going on to mute again? It's fine now. Now you're unmuted, sir. Please do not mute yourself.
Okay. So the sectors that are hard hit are mostly the unorganized sectors. Okay. And the small and medium sectors. The large sectors, the organized sectors, the big companies are not hard hit. The reason is that the bigger sectors, the organized sectors are not hard hit because they are all well established. There is high level of automation in these companies, and therefore, right from 23rd or 22nd March till today, most of them are working at almost 75-80% of the capacities. No sooner they were told that employees should not travel or employees should not move to workplaces, they started working from home. And because of the automation and connectivity like this Zoom and so on and so forth, the work has become easier. The world has become a village. That's what people used to say.
So, but what would you say about these sectors like travel, airlines, and all the companies which are in that travel sector, hospitality?
Correct. There you see, travel and hospitality is the most hit areas. And now, as an employment lawyer, I would say that the employers have been told by the government, central government, as well as by different state governments, that they should continue paying salaries during the lockdown period and should not go into any kind of punitive measures or retrenchment, etc., because there is no work to be provided. In fact, there are many state governments which have gone ahead and said that there would be prosecution if stop paying salary, or if they start retrenching on or laying off employees because of this reason,
Okay.
because there is no work.
Okay.
So yeah, so now your question was travel industry, hospitality industry is hard
Yes.
hit. But as far as the employment related issues are concerned, government is very stern that
Mhm.
you have to continue the employees, you have to continue paying their salaries.
Yes, sir.
Yeah. So whether the employers are able to pay salaries, whether they will be able to sustain by paying the salary, whether they have the capacity to pay salary, etc., is a different question.
Correct, sir.
Yeah, but if somebody has not paid the salary because of really not being able to pay, and because the smaller and the medium companies in this sector may have really become bankrupt because of no
Yes,
business
sir.
at all, not able to sustain. In that case, I don't see from legal perspective also that there would be a compulsion on the employer to pay them, pay to the employees. This is what I pursue, because if you have no capacity to pay at all,
Yes,
and
sir.
the government say that you don't function, you know, then
But
I
how
cannot.
will this be demonstrated? So, and because what would be needed to establish this?
I tell you. So, for example, a hotel, typically a hospitality industry first is hotel or a travel company. Now, in many places, the travel companies have booked tickets. They have booked hotels for their for their guests. Now, the travel has not happened. The people have not reached to the hotel. Therefore, hotel is not running business. There is no income for the hotel. With the result, there is the employees cannot be paid now,
Yes.
because the hotels have stopped receiving guests, except those guests who were continued after 21st because of the inability to move them out or maybe move them abroad. Except them, those who were detained because of the uh, environment outside, for rest of them the hotel was empty, hotels were empty.
Mm-hmm.
That means that you have no business and you are not able to do business because of a national pandemic.
Mm-hmm.
Now, if you see, if I break down this to the issues of workmen under the
Mm.
Industrial Disputes Act,
Yes, sir.
now a workman can be laid off or even can be retrenched if you have no capacity to give them employment.
Mm-hmm.
Capacity means then there are many things: the power failure, natural calamities, etc., etc.
Yes.
Pandemic will obviously will fall into those natural calamities. This is a natural calamity, though need not be earthquake or tsunami
Yes.
and so on and so forth. This will be
We
a
are
natural.
concluding that this is a natural calamity based on the central government's
Correct,
notification in the
correct,
with
correct.
reference to the public procurement policy,
Correct,
where it
correct.
is
Yes.
procuring from private sector. It has
Yeah,
said that we had a clause on force majeure where saying
yeah.
that a natural calamity could be a situation where a force majeure situation is invoked, and the government said that we consider this to be a natural
Natural
calamity,
calamity.
and
Correct.
we
And
can
therefore,
extend that logic you are saying by
yeah,
relying on that.
by relying on that and say that I'm not able to, because see, the philosophy of paying salary or wages is that the employer should have capacity to pay.
Hmm.
It is not a case that I have money, I am diversifying it somewhere else or hiding it somewhere else, and I'm not paying, or I'm making employees work and not paying. Here, I'm not able to give work, and the resultant I'm not able to pay. See,
Mhm.
this is like this. So there is a what you call the
This is called a lockout or what, sir? Under Industrial
no, no,
Disputes
no.
Act as
This
a
is not a
concept,
this,
no?
no, no, no. This is not a lockout. This is a typical situation of, maybe if you want me to relate it to an industrial disputes provision, it would be a layoff situation, not even retrenchment. It will be a
Okay,
layoff where you have no work to provide, and therefore you tell the workman that, gentlemen, don't come because I have no work.
okay.
Yeah. So this is a typical layoff kind of situation.
So, so then how do we interpret there are two questions. One is
Yeah.
that notification that has been passed, the order of the
Yeah.
government stating that you cannot, uh,
Stop the salary.
yeah, you cannot not pay salary, you cannot
Yeah.
have people, you cannot fire people
Correct.
during lockdown. So
Correct.
what kind of interpretation has to be given to that? If I give somebody a notice and then ask them to leave as per the contract provisions or as per the Industrial Disputes Act, there are scenarios where I can pay them 1 month or 3 months salary for undertaking retrenchment, and that means that the person is paid for the period of lockdown. I'm assuming that the lockdown doesn't go beyond, let's say, June 15th.
Correct.
Okay.
Correct.
So then how does it work? So that they have not been not paid for during the lockdown. So the government had said that don't cut salary. So
Correct.
they were paid for lockdown, and it may so happen that after the lockdown is over, they may be released from the job, but they would have been paid for the lockdown period when they didn't have
Yeah.
to
Yeah.
necessarily
Correct.
work.
Correct.
So is that something that is worth? Is that defendable before a court of law?
Yeah, I'll tell you. See, there are two situations which you are now thinking of. First is that during lockdown, I have not paid the salaries. Now,
Yes, sir.
once the lockdown restrictions are over, say from 17th or 18th or 1st of June, May or 1st of June, the situation is over. I am free to hire and fire. Okay. Now, if
I'm
my
free to.
business free to fire people
Yes, sir.
after this restriction, because so far
Yes.
I had a limitation. I
Yes.
had restrictions. Now there are in this, whether you avail the opportunity of firing or avail the opportunity of continuing your business. If your business is a continuing business,
Correct.
you would all the way prefer to continue your business, and therefore there is no need of your employees. In a given case, you may say that out of 100, I need only 60 or 70 employees.
Yes, sir.
What do you do with the remaining employees?
Yes, sir.
Now for remaining employees, say 30 or 40 employees out of your 100 employees, presuming that you will continue your business for some time, and you don't need all 100% employees for the time being till your business picks up for maybe 6-7 months or a year. You have to divide these 30 or 40 employees into two categories. First, who are the workmen and who are the non-workmen.
Okay.
Now, those who are workmen, you have to necessarily follow the provisions of retrenchment, which you are referring to,
Yes, sir.
right? So now the retrenchment, there are specific laws. Retrenchment is a typical kind of termination other than disciplinary action, retirement, superannuation, continued ill health, or etc. etc. Now,
Yes, sir.
if you have to, retrenchment is typically in a layman's language, it's a termination. The
Yes,
law
sir.
says as the Industrial Disputes Act says it as retrenchment. Only thing is that once you start, regaining your activity, you will have to give preference to these people, retrenched people, 30 or
Mm-hmm.
40 in our case.
Mm-hmm.
Okay. Now there are certain liabilities even while doing the retrenchment. That you have to give a notice of 1 month.
Yes, sir.
Okay. Then pay 15 months, 15 days salary for completed year of service. That kind of things are there. Then
Yes.
whether this notice applies to 100 employees who have employed 100 employees or more, or 50 employees, or 200 employees, 300 employees, there are state specific laws. The state governments have modified the Central Industrial Disputes Act from this applicability of the law on retrenchment. For example, Maharashtra says it will be only 50 employees. If you have to retrench your employees and you employ more than 50 or more employees, then you have to give a notice. There are states where the limitation is up to 300 employees. There are states where you have up to 200 employees. So if you are a small travel company, or a small hotel where your number of employees may be 100 or even less than 100, then you don't need to take this. I'm talking about the permission that you have to take
Correct.
before the
Correct. So
from the government.
permissions probably will not be forthcoming.
It will be coming from, because see, government, if you look at the move of the state government, not the central government, say
Yes.
UP government, MP government, they say that except maybe two or three things like minimum wages or payment of wages, etc. They said that, or I think there's one more, there are two or three restrictions. Otherwise, they say there is a complete exception to all the rules, central and the state acts. That means whatever retrenchment which we are talking about now
So where
will
is the
not be
complete
applicable.
exception to all the acts?
Yeah, completely.
The
See,
new
UP,
notification. Yeah.
UP
Yeah.
has already
Correct.
promulgated an ordinance. MP has followed the suit. I think there will be many governments will follow this, because government will have to follow this to give this kind of restrictions. If you tell me,
Okay.
if you ask me as an employer, I have a small, take our own example of travel industry or hospitality industry, I will not be able to survive and again restart my business unless you look at me with some kind of concession, right? So governments have to think of it. Therefore, UP government and MP government have started this.
Hello, Mr. Nayak. This is Purnima over here. Can you hear me?
Purnima has a question that she wants to ask you.
Yeah. Tell me.
Can you hear me, Mr. Nayak?
Yeah, you are audible, Purnima. Go ahead and ask your question.
Yeah, so just regarding this, the suspension of all labor laws has been in interests of all these employers associations, forwarding their requests and suggestions to the governments. But, I was wondering that is this, even if we protect acts like Minimum Wages Act, like what are the implications considering that, anyone can be arbitrarily laid off under these suspensions for 2 to 3 years at a time. And we are talking about laws that are in the hundreds. In state laws we have about 200 state labor laws and about 50 central state laws. Maybe this is a time for a more formalization of labor laws. What do you think, Mr.
Yeah, that's correct. But see, this is ideally, these are constitutional ethos that employees should be paid. There should be fair wage. There should be minimum wage. There should be parity. There should be equality. These are some of those
Directive principles.
Article 29, Article 38. 38, 39 and all, where look at Bahujana Sukhaya and Bahujana Hitaya. But this is an emergency situation. Look, for example, an industry, small industry, medium scale industry is not able to pick up. If he is not able to pick up, he will not be able to generate employment. And therefore, government thinks that since this being an emergency situation, it is advisable that you give him relaxation. So that once you give him relaxation, he will establish and come up to certain level. So that once he comes up to certain level, you will. I think we are.
So we can hear you. Please continue.
Yeah. So that the industry revives. And if you see this, they say it now 3 years because that's a guarantee to the employers, whatever kind of employers. Once and the government thinks that 3 years would be an ideal period to recoup and re-establish businesses. Once this is done, government will again you see now the constitutional laws will not permit you to perennially ignore central laws and say that I am the state and I have the authority to implement the state laws being in the concurrent list. But state or central also has an authority. If you look at hello.
Yes, sir. Please continue.
Yeah. So if you look at UP and MP, which I was referring to, UP and MP have not abandoned the central laws. For example, there is a bank in UP, say take any bank or an insurance company or a Office of Food Corporation of India or a port, airport or a seaport, water port. That there the application of the central laws continue. The state government has suspended the laws which are within the domain of the state government. That means if a central government employee is posted in UP, he will not be affected by these exemptions. That means the center is taking another approach, state is taking another approach. That may be because the center has more obligation as far as the applicability or the observance of uniformity across the country is concerned. The state government has, as far as it is the appropriate government, has suspended these laws.
Yes.
So if somebody has to somebody has to challenge these promulgations. For example, in Maharashtra, in Bombay High Court, there was a challenge given to MHA circular and the circular that the employer should not continue their employment, continue the activity, and also the employers should not stop salary.
Under the Disaster Management Act, the power of the government to regulate the private sector.
Government has absolute overwhelming authority to supersede all the central as well as the state laws. under this particular Act of 2004.
Yeah.
Yes.
Okay. Now,
Sir,
now this act or this act and the notifications promulgated under this act were challenged before the Bombay High Court in the Nagpur bench.
So I just have a question. The challenge pertained to the MHA order alone, or was there also a
No,
corresponding state government notification?
No, it
pursuant to
was central government,
Alone.
alone, but accompanied by the guidelines not to pay salary, so not to stop salaries of the workmen.
Okay.
Okay, so that
But
both
only central government instruments.
Yeah, only central government instruments. Correct.
Okay.
So, but then the High Court said the challenge is already pending in Supreme Court on the MHA guidelines, MHA
Yes.
circular,
Yes.
as to whether 2004 law is supreme or the other central parliamentary laws are supreme. Okay, nonetheless, 2004 is also a parliamentary law.
Yes.
Okay. So that question he said left it to the Supreme Court. As far as instructions to pay salary, he said that if the employee is required to work, say for an exempted industry during this COVID lockdown period, and he has not come, he has absented, don't pay him salary. But as far as those who are not exempted and they are required to pay salary, they should pay the salary. That means all in all, the government guidelines have been withheld.
Okay.
Yeah. So this is how going to be your challenge before the High Court of the Supreme Court.
Okay. So Shanmuga Babu has a question that he has wanted to ask you in this regard. He's a practitioner. He's a labor law consultant.
Okay.
No. Sir,
Hi,
I'm a vice president HR. I'm just picking up here, sir. Sir,
Okay.
I have a question, sir. Actually, what Indian Railways have done for the passenger side, where they had got contract laborers, they said they are going to only pay 70,000 in these circumstances, right? And I have that screenshot. And on the other hand, they have put these restrictions on private companies that they have to pay all these things. So we wanted to understand why this is and to what extent we can do it for MSMEs like us. And point number two, what I have read in the news is that all these state governments, whoever are suspending the labor laws for next 3 years, have submitted that file to the central government for approval. So on what conditions the central government would give you the approval, and it would be only the state laws or some of the central laws can also be covered. Like some of the states have their own state laws, as you rightly said, the minimum labor should be 50, 60 and all. That is question number 2, sir, relating to the same thing. And question number 3, companies have already gone ahead, although it is said the Supreme Court has still held the order and has not given any conclusion on the payment of wages and including permanent workers. Many industries, I don't want to say it is unlawful or they have violated the law. They have gone ahead and discussed with the unions, it seems, and concluded that they cannot pay and have already started the exercise, and they have not paid for the month of March or April whatsoever. So in these circumstances, do you think whoever has been paying so far or whoever has doesn't want to pay because they don't have the capacity to pay can exercise the retrenchment immediately for this month of
Shanugam, I heard your first question and the last question, and between there was some call coming, and therefore I was,
no problems. I'll once
anyway, I'll address the first question first. The railway contract employees. Now, as far as contract employees are concerned, the government is very specific that there is a more stress on protection of contract employees. Therefore, as far as non-payment of salary or termination of contract employees or non-payment of salaries to contract employees per se is prohibited. Now, if railways have said that they will pay only 70%, etc., because you should also remember that the railways have not functioned during last 50 or 55 days. Okay. I hope I am audible.
Yes, sir, I'm hearing you.
Okay. So you should also remember that for almost 50-55 days, railways have not functioned. The contract labor is primarily hired for running day-to-day upkeeping, the day-to-day housekeeping of the railways. Added to that, therefore asking them to pay a huge staff. Railways have lakhs and lakhs of contract labor.
Yes.
Like you had airports and those airport legal history. Now, even railways have a checkered history on contract labor, and Supreme Court, High Court, as well as Supreme Courts have not favored the workmen, the contract labor, but protected railways, saying that this is a public utility services. Number one. Number two, railways, because railways have not run, because the railways have not generated revenues. Therefore, this being a contract employee is incidental to running the railway industry. Even courts would say that not paying salary or paying lesser salary is justified on a principle of fair play. Now you have to also go into the railway laws. See, there is a separate railway act.
Okay.
It's a law made by the parliament in plenary session.
Okay.
It gives ample powers to the railway board to decide about the salaries from time to time to different employees.
Okay.
Okay. Therefore, if ordinance has been promulgated under the powers of the Railways Act, that would be considered as a subordinate order, subordinate legislation under the Railways Act, which will be perfectly in order to uphold its legality and constitutionality.
Okay. Okay.
That will be supported by the rationale that the railways did not work, did not function, did not earn any income, and these employees, being contract employees, not permanent employees, not regular employees, were meant to support the day-to-day working of the railways.
Okay.
So, in law as well as in substance, the railway would win.
Okay. Okay, sir.
Second question was I got this understood.
Sir, second question was that can we also, you said we can, introduce the retrenchment provision, and many of the corporates, I don't want to say that they have violated or not. They have already started not paying full salaries to contracts and workers. But some of the enterprises have, because of this legal, order, some of them were in a worry, like why to attract unnecessary, pressure from labor, because PMO has said that, no, we are watching this and all. So some people have paid. Now they are feeling the pinch because in the going forward, the days are not going to be that good as how the production is.
Yeah.
So what exactly all MSMEs can start immediately to reduce the burden of both permanent workers as well as contract?
Yeah. See, if you see these, central government, even I've seen orders of Maharashtra government, I've seen orders of, I think AP or not, I think AP or Telangana, which include, they are almost in harmony with the central notifications on, not stopping salaries of the contract labor. Now, see, there is a technical loophole here. If you are a labor lawyer, you would tell the employer that now, see, the contract labor is always through a third party, and there is an agreement between the service provider or the contractor or the labor contractor and the company.
Okay.
Don't say employer, the company.
Company. Okay.
Yeah. And now, as a lawyer, you will tell the company that, see, because of, for many reasons, including reasons of no evocation or no activity for, around, let us not continue the contract with so and so contractor.
Okay.
I am perfectly allowed in that.
Okay.
Government has not said that you suspend your agreement with private parties.
Okay.
Okay. Current instructions say that you continue paying salary to contract employees.
Okay.
So once you say salaries to contract employees, it is not limited only to contractor, it also extends to the principal employer.
Correct.
So this is what it is. But if I say that I am terminating the contract with Mr. Ashok Naik and company, who was providing me manpower so far, I have no work, and therefore, for whatever reasons, you don't have to even give reasons. I have terminated the contract in terms of so and so of the agreement between me and Mr. Ashok Naik and company, a service contractor, a labor contractor.
Okay.
Once this contract is terminated, now the obligation rests only with the employer, with the immediate employer, not with he has no aid or assistance of the principal employer.
Correct.
Yes.
Right. So now, as a contractor, the employees have to come to me and say, look, gentlemen, you have hired us, you pay a salary. He will say, sir, the contractor will say, sir, I was banking on some of these big companies who were giving me work. They have stopped giving me work. I have no work. Where do I generate money? I cannot give you, forget about giving you job. I cannot give you a layoff compensation or replacement compensation.
Correct.
So, and if suppose this fellow, if this action is challenged in a court of law, court will say, how do you gentlemen expect him to give salary or work? He doesn't have work. His business was to approach some employers, take some work and give it to these poor boys.
Okay.
In the process, he was also earning something, and these boys were also earning. Now he has not got his contract renewed or contract terminated for whatever reason, because that company was not able to first continue the contract, or they did not want this contractor to continue.
Okay.
Therefore, the liability of the principal employer is cut off.
Okay.
Now, as I said, now the liabilities only rests with the immediate employer, the contractor. The contractor will anyway say, I have no work, what do I do?
But technically at this point, sir, there is enough, unless there's a suspension of the state labor laws, there is the MHA order pending saying that don't cut salaries of people. So at least with respect to the contractor and the contract employees, the contractor as their immediate employer has to make sure that he pays them the daily wage.
Yeah, that's my question. Yeah.
That is the correct position as of now.
Okay. Okay, sir. The third question that I've asked is that these states suspending the laws have sent that file to central government seeking permission, right? UP has sent
say it again, please. Say it again.
So the states, whoever wants to suspend the labor laws, have sent those files to central government to obtain permission. That's what I read it in the news. And in Karnataka, the state government, to relax the labor laws, have started negotiating with AICTU unions and all. So am I wondering, can the state directly say the state applicable laws have been suspended, or they should wait for the permission from central government, and then only we have to wait for the notification to come?
No. See, under the Constitution, this being a concurrent place, state has full powers to make or amend or revoke a law. Okay. Now, there is also a constitutional provision that every law that is made by the state legislature has to be placed before the President of India. Okay, for the concurrence. It is nothing but a rubber stamp. Nothing but a rubber stamp. Therefore, it will be, and that I think there is a period of 6 months or something. Or I remember, I may not be correct. I think there is a period of 6 months after passing a law. In this case, it's a promulgation. So promulgation will be after first 6 months. They will continue as it is till the assembly sits in session. In the assembly, they will place it as a bill, and that bill after notification will be placed before the president. Okay, and the president will have to give concurrence, because president will go through the concerned ministries. President doesn't function on his own. He has to take permission, or take recommendation or notings from the concerned ministry, or the in technical language, in constitutional language, the group of ministers. So naturally, the group of ministers for UP will say that the UP government has done, UP assembly has done the right thing, and the president will give assent to that. That's a very simple answer.
Okay. Yeah. Thank you, sir. Thank you.
Yeah,
it was pleasure hearing your views and all. Yeah. Really nice. Thank
you. Okay. Thank you, sir. Thank you, Babu. Now next is, sir, Vitesh has a question on a layoff related issue.
Yeah.
I'm going to unmute Vitesh.
Yeah.
I'm taking questions, sir, as I see a flow also in the themes that we are discussing, and then somebody says that I have faced this question. So yeah, Vitesh, you can. I've unmuted you. You can ask your question.
Hello everyone. Good afternoon. Thank you so much. Actually, I was just working with a Chinese company. I got an offer in the month of February 2020 as an regional sales manager. That company is into medical equipments, and all my reporting bosses were directly from China. So now they have just gone to China in March month, and then because of lockdown there is totally no sales. I'm not able to go outside and all that stuff. So they have just laid me off. 30th April was the last day, saying that there was no sales performance of yours. So I just want to know within and the contract was of 1 year.
Okay.
So within a 1 month of time, how can they say in a lockdown period that you are being laid off or your contract has been terminated? And in this regards, I have mailed my query to the Labor of Ministry Law at SK Sahu DD
Hmm.
in Delhi, and
Chief Labor
then
Commissioner. Yeah.
yes. So I am currently into Mumbai. So they have forwarded my complaint to mahalabor at
Hmm.
gmail.com and psec.labor@maharashtra.gov.in.
Okay.
So
So
basically, they have forwarded to the Labor Department to take
Yeah,
action, and
this
employers.
is center has sent it to state government labor department.
Yeah, yeah.
Okay. Okay. The center also has an office in Mumbai. They did not send it to center.
Okay.
That's because this Chinese company,
mhm.
government of India doesn't have to do anything. See, this is a private company, so therefore, if it is in Maharashtra, it would have
Yeah.
Maharashtra government would be the appropriate government.
Appropriate government under different labor laws.
Yeah. So now coming to to your question, your employment is between February and April, and
Yes.
out of that, 1.5 months almost
hmm
was during lockdown,
Yes.
and February and March means 1.5 month was actively worked, and 1.5 month was actively not worked.
Yes. Yes.
And therefore, after 3 months, they said that we whatever reasons the contract is terminated.
Yes. Yes.
Now, since you are appointed as a sales manager or regional sales manager, you would not be falling under the anywhere in between the protected labor legislation.
hmm
Your employment will be purely contractual.
hmm
Therefore, you have to read your contract of employment as to what it says. What are the provisions about termination of contract? What are the provisions about notice in lieu of termination, or what are the provisions for notice prior to termination of contract?
hmm
So, if any of these three things answers your question as to how I could have been terminated after 1.5 months of effective employment, they should answer. If they don't answer, you have a good ground to file a civil suit against the company, provided the company is there, company is able to fulfill the commitments of commitments under an order of a court.
So, but they have sent me an mail regarding the termination of contract, wherein they have mentioned that due to poor sale performance, no sales, no proper behavior, your
How much
contract.
time did you get in that? Like, is it on the spot termination? They said that no performance, therefore terminated, or you've been given a notice of 1 month to improve your
They have
performance. What
given
is it?
only 10 days. I mean, 20th April they have sent me the mail,
Yeah.
and they have mentioned on 30th April would be your last day.
Okay, but no, but what is your terms of appointment? See, it all surrounds around. If no sooner you are not a workman,
Yes.
you have to look at your terms of appointment.
So this is actually applicable to everybody who has faced
Yeah, yeah.
any scenario
Same,
where you've been
same.
asked to resign or take a reduced cut or leave without pay, or you've
Exactly.
been asked to leave. So
First, you have to
everybody,
see.
this will be useful.
Yeah,
Yes.
yeah. First, you have to see whether you anywhere you falls within the ambit of a workman.
Mm.
By stretch, even by huge stretch, try to relate you to a workman. They try to take the see the attributes of a workman under the Industrial Relations Act. If not, then the answer is you have to see your terms of appointment. Or if there's a big company, look at its HR policy or personnel policy or
It,
whatever. If it is in your hand, that may
actually,
also give you some respite to fight in the court.
So Vitesh, what sir is saying is that financially there are two things. Okay, if the
Yeah,
company has no interest in India anymore and they have just left, then you will have the whole burden of sort of taking this up in the courts and then pursuing them.
correct,
So it will
correct,
turn out to be a losing battlefield. If
correct,
on the
correct.
other hand the company has an office in India, still decides to continue presence, then you might have some leverage. You can
Correct.
go to the court, or the labor commissioner can take
Yeah,
some action against the company, and the company will give you either an opportunity or at least 1 month's compensation, because
no, not
standard
labor commissioner, because labor commissioner may not entertain him,
they will not
because
entertain now.
he was a regional sales manager, and therefore there were prima facie there were managerial responsibilities. Okay,
Okay, okay.
promoting sales and
But
all.
under shops and establishments,
No, no,
labor commissioners are hearing.
no. For if you are in Maharashtra, Shop and Establishment Act
Yes.
doesn't provide for such provision.
just
Okay.
sorry to interrupt. I just
Yeah.
want to clarify that the head office is in Delhi, And in Mumbai, there is a sales office which they have just recently started in November 2019.
Okay.
So in Mumbai, they don't have any department. There is only one office, and two Indians are working. Myself and there is one more lady.
Okay.
But the
Okay.
head office is in Delhi.
No, head
And
office doesn't matter. Your employment is in Maharashtra, and therefore you will be governed by laws applicable to Maharashtra.
okay.
Okay. So first thing you have to see is how your appointment order reads.
Yeah.
Mhm.
Yeah. So because since once you say, as I said, once you say you are not a workman, or you try to stretch yourself as a workman and see how best you benefit you can give. But that will again depends upon what work you are given and what work has been defined in your letter of appointment. If there is a letter, if there is a letter of appointment. Okay, if
Mhm.
you are
Mhm.
sales manager and all that, and then that it was expected that
So
you should
most
have been.
letters of appointment, if somebody is doing this on non-performance also, you will have at least a week's notice to improve your performance and some
Yeah,
clarity of
yeah,
targets,
correct,
opportunity to represent,
correct,
which all
correct.
hasn't been given to him. So that
Yeah,
is
correct,
something that
correct.
it goes
Yeah,
against the
and
company.
it
Now he
goes
has a
against the company, but you see, there should have been a condition precedent that there
hmm,
would be a notice.
yeah.
Suppose if he was, according to the company, he was a high profile performer,
Hmm,
and if he wanted to leave it, just put in your papers today and leave, discontinue from tomorrow and join some other company or a competitor, they would not have allowed him to do that. They would have said that no, you have to serve for 3 months or 2 months or 1 month or whatever, which is there in the letter of appointment. And therefore, good companies always, the competitive firms, always put a notice clause. It is sometime it goes to their retrograde, but most of the time they benefit them because the according to their view, if an employee is a high performer, he would still continue after submitting notice of resignation for whatever period, 1 month, 2 months, or 3 months, or whatever. In some cases, it even 6 months.
Yes,
So
but
you have to see. So you have to see, Hitesh. You have to read your appointment letter as to what is it. If it doesn't provide anything, I would say still you have some kind of recourse, saying that there is no notice period and there should have been some kind of notice period. Okay, all this you can do provided the company still has some existence in the country and would be able to honor the order of a court.
Mhm.
Now, for Maharashtra, since you are in Mumbai, your posting is in Mumbai, right?
Mhm. Yes, Mumbai.
Yeah. So Maharashtra Shop and Establishment Act also doesn't provide you anything. Now the remedy left out is
in
only
some in some other states, sir, I think the Shops and
yeah, yeah.
Establishments Act provides them benefit and they can go to
Correct.
Labor
But
Commission.
I don't think they are registered for shop and
No, no.
establishment in
Even if it is
Maharashtra.
even if it is not registered,
Maharashtra doesn't allow, sir.
no. But even if it is not registered, the act itself doesn't provide such any relief for such cases. In Maharashtra. If you
Yes, sir.
had it been in say Tamil Nadu, Kerala, in the north, Bihar, Chhattisgarh, and so on and so forth, you would have got some respite. West
Yes, sir.
Bengal. Yeah, but
Ritesh, now
in this case, the only remedy is to study your letter of appointment, see if the employer still exists and would be able to discharge any order that the court may provide,
Hmm.
and go to a civil court
Okay.
and file a civil suit. It all depends upon how your letter of appointment is worded.
yeah,
Okay. Thank you so much.
Yeah,
Thanks.
thanks, Ritesh. Sorry that took long, but I asked everybody whether that's relevant because the process that you use to follow
yeah,
to identify whether your how you are to be dealt with by the organization, that is clear and same process is applicable to everybody. So
yeah.
Prachir Sogani, who is a labor law consultant, has asked HR and labor consultant has asked the question that Rajasthan government has issued an advisory regarding payment for 30 days of April. What legal force does it have, and do employers need to strictly follow it?
Okay. See, this question
So
was
it's an
asked to you.
advisory.
Yeah,
Prachir
yeah,
Sogani.
yeah. So you see, this question was asked even when the central government issued an advisory on
Yes, sir.
payment of, not stopping the payment of employees. I am employed in a bank currently, and I have received not less than 100 complaints filed with the Government of India Ministry of Labor for not paying the salary or to not allowing to work from home. Banking is an essential services, and uh, I cannot be compelled to pay salary. when employee says that no, I cannot come because I cannot travel, I cannot come, and therefore still you have to pay me salary, because there are some guidelines that government has to pay salary. I mean, the employers have to pay salary. It is, yes, employers have to pay salary. I'm little diverting the issue. Employee, because I have to relate this issue to Rajasthan case. So employers have to pay salary, but if there is an exempted category, then this question doesn't arise. Employers don't have to pay salary. Now, if it is an unexempted category, whether the instructions or the advisory is binding on the employer or not. If you read this principal act, the Disaster Management Act, and if this advisory is under the Disaster Management Act, which we should say that this is a subordinate order under the Disaster Management Act, because the Disaster Management Act 2005 allows state and the central government to make rules, to give instructions, to give advices. If this notification has a reference to the DMA 2005, then the order cannot be challenged.
So is this a real advisory, or is it like the
No, by advisory
directive?
Because see, government also acts very diplomatically sometimes.
Yes,
Because see, if the employer who has come to government with a prayer, with the folded hands, sir, you are asking me to pay the salary, but where from do I pay? So then at least that advisory will help him. In the sense that at least he will go to knock the doors of the court, or somebody else goes to the court and this fellow is dragged. He will say that, sir, I also wanted to pay the salaries, but where do I pay from? I don't have anything. And on top of it, government is aware of the inability of some of the employers who are not able to pay. That's precisely because they said it is advisory. And otherwise they say this is mandatory. They did not say it is mandatory.
Yes, sir.
But if there is a strong company, very high profile cash rich company, and goes to the court, sir, it was advisory, how did you compel me? They will say, go to hell, you have to pay, because this is an advisory of the government. I draw power from this particular act. Though I have used it as an advisory, it is binding on you, and no court will entertain. So this is how government usually, because government also has to run those industries.
Yes. So the irony now is that in states like UP and MP, labor laws are being suspended, but in other states it's not being suspended. And so employees who've been asked to resign or leave without pay or being laid off, if they complain to labor, I don't know what other ways they can complain. So there are two options. One is that the notification somewhere said that state governments are to locally implement these also. So sometimes that local implementation may be lacking. If it is there, then somebody can go to the police directly and say that I have been laid off. And in other cases, if you can go to the labor commissioner. That will depend on whether the Shops and Establishments Act in that space allows you to do that. If that allows you, then under Shops and Establishments Act, you are not required to be a workman. You are required to be a workman only under the ID or Standing Orders Act.
Correct.
So, which means that in the other states, what does somebody need to do? Where the labor laws are not suspended and an employee has been asked either to leave the company or retrenched or go on leave without pay or said that, okay, work at 30% less. Now, what is your input for these people? Like, what should they check if they wish to file a complaint, and what they need to do? And also the financial part, like, if the company doesn't have money to pay, then filing a complaint probably is not going to work out even for the employee. So what should be a balanced approach here?
Yeah. This is what I was telling, advising Hitesh also. First, you have to see whether the employer who had employed you so far has really some worth that, he continues even after COVID restrictions, he continues his business, or he wanted to wind up anyway, and therefore he got an opportunity to wind it up. If he is continuing, then that means that we have some hope that this fellow will be able to honor the order. Number one. Number two, those not exempted companies means what? Banks, insurance companies.
Yes, sir.
Then your hospitals, doctors, that kind of transport, the public transport, hospitals, doctors, medical equipment manufacturers, medicine manufacturers, etc., are exempted. So there, if they have terminated you, you have very strong case that you cannot cry and say that no, you could not do business. We said we allowed you to do business, and therefore the cases of employees of these companies are very strong. Now the cases of companies which were not exempted, I mean, did not have any leverage to run business, other than the company which I named, the industries which I named. Now for them, again, if the employer is doing well and will be able to honor the order, and the employer is there, recognize that somebody is there, then we can definitely, if depending upon which ministry it is, if the state government is the appropriate government, they should knock the doors of the state government under the Payment of Wages Act. Again, for the Payment of Wages Act, there are limits.
Industrial establishments, unless it's notified in the state for other
no, that is not necessary. Industrial establishment, but Payment of Wages Act has certain minimum employees employed, 10 and 20 employees.
Yes.
Okay. So irrespective of whether somebody asked me whether it is registered under the Shop and Establishment Act or not, that's not required. There's nothing called, then there is nothing mandatory on registration as far as labor laws are concerned. The limitation is whether there are 10 or 20 employees, 10 with power being used, and 20 without power. That is the minimum requirement for most of the these obligatory labor welfare socialization. So now, if any of this is there, any of the persons who is working under this can knock the door under the authority under the Payment of Wages. So you have to find out which authority is it. For that, best way is to visit the office of the Labor Commissioner of the state government. I am talking about state. I'll come to center later.
Yes, sir.
So for in every district in the state, there is a labor officer's office, who may be called Assistant Labor Commissioner, Deputy Labor Commissioner, sometime Labor Officer, sometime Regional Labor Commissioner, sometime District Labor Officer, and so on and so forth. So most of the time, he would be the authority under the Payment of Wages. 99% of the cases, he would be the authority under the Payment of Wages. So he will ask you what is this, and then he may give you a form also. There are state-specific forms also. So you have to fill the form and give it to him and say that
is for a claim of wages, the notified form.
Yeah. This is all past wages.
Yes.
And then when the past wages, there is an order, he has to either follow it, or employer has to either follow it or go to High Court and challenge it. And because there is an order for the past period, your question was as to what happens to the future period. Okay. Now I'll give a pause on the future period. So when I talked about district labor officers and all, if your sphere is under the central government, say for example ports, airports, the seaports, banks, insurance, cantonments, I don't know what all, coal mines, these are all covered under the Central Act. Okay. So central government continues to be the government for them. Okay. And also some public sector, the central government undertakings. So under them, there are offices of the Labor Ministry of Government of India. For example, in Mumbai, you have an office of the Deputy Chief Labor Commissioner Central in Mumbai, which is somewhere in Chembur, Sion Highway.
So are these offices fully functional in this period?
Yeah, they are completely functioning. I receive notices day and night from them.
They are doing the regular hearings for employees also for claims?
No, they are not doing hearing. Right now they are not doing any hearing kind of thing. Okay. They have opened control rooms in different places. Labor departments, control rooms.
Okay.
And anything going to them, they say that you give response within 24 hours. Resolve the issue within 24 hours and give us
confirmation.
The confirmation.
But so basically, the hearing under Payment of Wages Act is not happening. So does that mean that adverse order cannot be passed?
It will happen. No, it will happen. Now once this lockdown is over, this will happen.
So that's that wait period that an employee and the employer will have.
No. You see, there is a period, but the period is very long, 6 months period and all.
So if an employee has an issue, one thing is, sir, that the labor office will say that resolve in 24 hours, and it puts pressure on the employer because the office is acting faster than usual.
Absolutely.
But in terms of the 6-month period, the order will still take 6 months to come. So an employee who's hopeful that the labor commissioner will protect me has to be willing to go for a wait of 6 months if need be.
Yeah, it is better to wait for the, otherwise what is the other recourse?
No option is also there, correct.
No other.
But the other recourse, for example, is to consider that whether I am willing to take, let's say, a pay cut or a leave without pay, or if I get 3 months compensation and resign, because a lot of employers are doing that, take 2 or 3 months, which is what is written in the contract, or a month more of salary, which is basically giving the employee some leeway to some time to rest, apply for other jobs. You have money, so that is the alternative that some employees can consider.
Correct, absolutely. See, if you employ, most of the places employees do understand that there is no business happening.
Yes, sir.
No, and if there is no business happening, I cannot expect that I should be paid my salary. If the employer is, in spite of there being no business, and the company being small, medium, MSME type of company, and if employer is prepared, in spite of there being no activity, no work, no activity, no creativity, no order, no production, no sales, and still he says that I will pay you 50% salary, I should thank him and say that, okay, you have bad time, I also have bad time, but let us share the bad time. Otherwise, if you try to stretch it, it will be like, when I started my career sometime in 1979, in 3 years, in 1982, there was Bombay textile strike, led by Dr. Datta Samant.
Okay.
I have seen it. I was into an industry which was akin to manufacturing textile mills. No, so the strike started in July, and took full strength in September 1982, and it never ended. It still continues to till date, from 1982 till date. But
Okay.
what happened? The employees have lost. The employers, the owners never lost. They have sold the property and they have made huge sky-reaching towers and got the money. So employees also should show an understanding, so that let the employer regain its lost ground, and be able to gain a position by which he would be able to give me further work and more work, and again the salary. This is
Yes,
how
sir.
it is. This is
Yes,
how it
sir.
is. We have to also be reasonable. Why with all that there is an obligation that you must pay and all. That kind of approach will not be shown by government bureaucrats or the judges or the juries.
Even in the government, there are bureaucrats who've taken pay cuts and offered to work for
Even
over
judges have taken.
Yes.
No judge will say that no, in spite of not being there, no business, no work, and how do you expect that you should be paid salary? Where from will you bring salary to him?
Yes.
So you have to show considerable understanding. Then only judge will say, यार 50% तो देने को तैयार था ना, 50%
Yes, sir.
के लिए आप ले लो ना, how does
Yes,
it?
sir.
Where from does he bring his salary? He has to
Yes, sir.
generate revenue.
Correct. Yes.
Yeah.
Purnima also had a question, sir, for you regarding the PM's announcement. Purnima, I have unmuted you. Would you like to ask? So this is our last question for the session, and then we will wrap.
Yeah.
Yeah, so I was just thinking that this discussion has led to understanding the kind of relationship, the kind of compromises employers and employees both will have to make in this scenario.
Correct.
And other countries, like of course, they're much more developed countries like New Zealand, Canada, etc., have tried to partner up with these industries and created packages where the government itself is funding the sort of salaries that will be paid to workmen, etc. Do you think, like, we still don't have much news on the 20 lakh crore package that the PM has announced as to the semantics of it, but do you think that where a good way of such money being invested is the government itself bailing out a lot of companies, helping them out so that the economy can sustain itself and the employees can sustain themselves in the company?
Yeah, you have answered your question actually. See yesterday's Prime Minister's announcement that there will be 20 lakh crore fund being given for redevelopment. It is actually redevelopment of the industry. Okay, of that RBI has already started interest-free loans, cost-free loans for a particular priority sectors, loans for agriculture, and so on and so forth. These are all activities to see that the industries which have fallen sick because of this are reinforced. They gain food, they gain some ground and stand up. India is still not in a position to adopt a Western culture of paying unemployment compensation, unemployment pension, and unemployment salary, etc., which you refer to Australia, New Zealand, Canada. They have pension schemes or unemployment benefit schemes for their residents or their citizens. But India has not reached up to that level. We are still a developing country. And therefore, this 20 lakh crore is because of that. And in that, of course, I think today, this evening, finance minister is going to show the allocation, industry-wise allocation, and so on and so forth. But all in all, this package of 20 lakh crore is primarily meant for rebuilding the industry, which has either lost because of this or which would be still losing ground because this lockdown, though presume that this lockdown will be completely lifted on say 1st of June or whatever, say 15th of June, it will be lifted. One day it will be lifted. It will not be too far. It may be 1st of 17th of May or 1st of June or 2nd of June or 3rd of June. Once that is lifted does not mean that your normal economy will be restored. Many businesses have perished. Many laborers have decamped. They have migrated to their villages and natives and so on and so forth, 1,000 kilometers, 2,000 kilometers away from the workplace. And therefore, cities like Mumbai, Pune, Bangalore, Calcutta, Jaipur, Ahmedabad, Baroda, bigger cities which were, which had labor intrinsic activities, the labor has moved out. The labor has moved out, and these people have moved out with a pain in their mind. They will not be returning immediately, even if you say that, gentlemen, I will pay you double salary from tomorrow. Come and join work. They will not come because they have suffered for, I think, more than 2 to 3 months. And then after becoming, so fed up with life and the place and the surrounding because of this pandemic, they have even walked on foot for 1,500 to 2,000 kilometers. So it will be there in their mind and heart. I'm not talking about governmental policies, etc. This is the reality. I'm talking purely from
So industries may have to incur additional costs, hire new kinds of workforce, train them, and government bailout packages. I don't remember offhand, but when the financial crisis had hit in 2009, 2008 in the US government had started certain bailout packages for companies such as AIG, which was the American insurance group. And government bailouts come with certain terms and conditions and government controls, which can increase the compliance or the financial cost of using that bailout and give government a lot of rights to convert or to give instructions. Yes, sir, please.
Yeah, I only I did not add that in India, the bailout or aid in direct or indirect form will not come to Indian industry except you are a government avocation. For example, public sector banks, public sector insurance companies, public sector undertakings like transport, shipping, transport, or whatever,
Okay, so this is for public sector organizations which are crucial to the economy,
where there is a provision for budgetary provisions for aiding and supporting the activity.
This would be there in their parent statutes or in their articles if they are corporatized.
Or any evocation which is run by government or in the name of government. But so far in India, there was nothing called government directly supporting a private institution.
Correct.
And they may say that, okay, now for 1 year don't pay income tax.
Yeah.
Or generate some profit and flow it back, till then you don't pay income tax. This kind of things will come. I was told that there is some kind of provision of calculation in this 20 lakhs about exemptions of income tax and the GST for some of these SMS, small and medium industries, or even small industries, or the agricultural and tiny sectors. so that they get a breather for at least 1 or 2 years by way of exemptions of GST or income tax, or maybe local authorities charging them for whatever. That kind of exemptions are given, or even import substitutions, or import subsidies, or even export promotions kind of thing can be or have been given by government on private for private institutions.
Okay.
That is what yeah, that's how it works.
So I want to thank you, sir. This was extremely useful, and we're past our time also. I want to really thank you for taking out the time and sharing your insights. And thanks for everybody for joining in. In case I've shared a YouTube link with you for you to share and rate the video so that it gets more traction, more people can access it. This is our intention is that it gets maximum visibility and it is used for education of people. And in case some of you are interested in more inputs, in learning more, you can visit our website. I have mentioned the link for our labor law course, and you can check it out. And I'm going to invite sir to take a couple of guest lectures in the course as well on technical topics, sir. Thank you very much. And those of you who want to inquire more about the course can reach out to me on my WhatsApp number. My WhatsApp number is 9717301797. Okay. And yes, we are covering labor codes inside the course because they have not been notified. So you have to keep preparing for the transition when they get notified fully. So we have covered that in the course. Right now, we will not be discussing that. But thank you, everybody, for being there. Thank you, sir. Stay tuned. We will keep bringing you more exciting webinars.
Thank you so much. God bless you. God bless you.
Thank you, sir. Yes. Bye, everybody.